I started, so
Alrighty, y'all. Everybody, what's going on, party people? Welcome to our Newbie Tuesday, right? Our friends-in-law Newbie Tuesday, also known as Bible study, right? It is allegedly, right, the 31st day of March, 2026, on a Tuesday, right? A Mars Day. It means we're active here in Newbie Tuesday. I trust everyone has their Newbie Tuesday questions ready. Seems like it's quite a bit of success story energy in the air too, right? Quite a bit. And I trust that we're doing all our due diligence to go gadget, keep a foot on the attorney's necks. And I trust we stay in that same fashion, especially after me recently, just a little earlier today before class, hearing quite a humble tone and tune from the attorneys that defend those that we are putting complaints against, especially when it comes to those consumer complaints. They're not as arrogant as they sounded last strong. They're sounding absolutely humbled, if I could say. Absolutely humbled to the point where they're saying we have to make sure we have that assignment, and we have to make sure that we're not really running a risk because it seems like a lot of the pro se litigants are making sure that we have everything intact, and the judges are really making sure that we have all those things also. And all I could say to myself was
They stuttering because they lying.
They wasn't talking like that about less than 7 days ago. I promise you they wasn't. They was talking like, yeah, haha, sovereign citizens trying to say this, haha, pro se litigants, they think they know this, they think they know that. Today it was like, yeah, we need to uh um we have to really make sure that we really have we can collect the debt and have our professionals in order. I was just like, the ones that I know usually yeah, I was like, that's a whole different song there. I mean, you know how when somebody's pumped up, yeah, because they can't do nothing to us. You know how you pregame, man. Every attorney was like, yeah. So even the judges are saying to make sure we have those valid assignments because and plus, we're having pro
Even the
se.
judges, you mean the law? The law is saying that you need to have those goddamn assignments, the delegation of authority,
Tell you
the
what else
board resolutions.
Let me tell you what else I heard. There are pro se litigants that have done electronic signatures so that when we're disputing it, so when they're disputing the signature. And obviously, it's not going to be the same because they're showing pictures of their quote unquote driver's licenses. And so that's running an interference for them to successfully be able to collect the debt also or whatever. I was like, wow. And then listen, the attorney was like, it's not like we can really bring up the original documentation for the credit anyway.
Oh, they don't have the instrument securing the underlying obligation?
and they said that out loud.
Out loud to the point where I repeated it in the chat where I was viewing it. I was like, tell us more about how you don't have the original or can't go back to it. We love that story. That's why I was like, so look,
So they're using what, self confessions to
they're dwindling.
what is called confess judgment, right?
Yeah, self-confession. That's what most of us all have, you know, have at some point in time maybe struggled to not do to ourselves because, like you say, no need to talk, right?
Right.
Unless you're speaking to remind the plaintiff of their burden,
Right,
which doesn't require you giving any evidence whatsoever,
right.
and it's mainly our ego.
Because we
That's
do the work
typically
for
for
them.
when we're new, that we feel like I have learned all of this stuff, instead of what I think is the really happening is we're unlearning stuff. Because when we went into those transactions, we thought we knew what was going on. We thought we were like, I'm getting a credit card. I'm buying a car. I'm buying a home. I'm renting a house or an apartment. That's what we thought we knew. And then after you actually unlearn, you realize I didn't know what was happening during that transaction.
Word.
And then you were misled to believe what you did believe about that transaction, making it unconscionable.
Right. Because whenever I, say applied for a credit card, I was expecting for it to be kind of like whenever if you wish to borrow money from a friend, you say, "Hey, can I borrow the money?" And the friend actually gives you something, that now they have less than what they did, and so there is an obligation that to make them whole again. But when you find out what's going on with these commercial credit counts and things like that, they're not really giving you anything, that so
yeah,
they're
definitely not giving you anything that makes them less whole.
Right.
They're not.
The conditions are not
unlike
what
your
you
friend. Your friend has to go under their mattress or go into their bank account, right?
Yep.
And reduce it from an amount to then give it to you. And that no such transaction happens when we go into banks.
When your friend has a printing machine or just a thing, exemption on his computer that lets him just put in whatever number he wants in his bank account. then it's not so bad. Then you're like, okay, I don't really feel so bad about that, because I thought you were actually going in your mattress and getting the money.
Yeah. Yeah, or going into some type of an account that you have a sum certain in, and you have to now minus whatever it is you're giving me, whether it's $1 or $100,000.
And if I may,
had the master code.
Go ahead, Jake. My part.
I was just saying, I didn't know you had the master code to the system.
Indeed, if I may, because I don't want to put anybody else out there, but if you were present, am I the only one that heard those things that I said that I heard in opening class today? Just asking. Put a 1 in the chat if you heard it too. I just want to know. I want to make sure I'm not hallucinating like a large language model over here. So, anyone's in the chat on they heard it too? Oh, okay, there's one. So I wasn't the only one that heard it.
Heard what?
That those attorneys are saying they don't have the originals, saying that the judges are saying, letting be known they need to make sure they have the actual assignment, chain of assignment, all of that. Whereas less than 7 days ago, they're like, yeah, they think they know this and that, and they're just using AI, and they can see they're doing things that it does not even called for yet. And so what it makes me think, now this is going to be far-fetched here, so I don't want to break my wrist from tooting my own horn. However, I think whatever it is that we do in these venues, they're sharing them coast to coast. And just for about a good 15 minutes, I couldn't let go of the thought of our friend-in-law near Maryland, where they still was like, no, we're still going to do what we do. You know what I mean?
They're uploading them to their AI, I bet.
That's probably it. However, if that's the case, that means we're infecting them and infecting their way of doing things to the point now they sound a lot more humble. They don't sound as arrogant. I'm telling you. That's why I was asking, put a 1 in the chat if you heard them sounding humbled. So that's it. It just makes me think like maybe some of the things that we've been giving our jurisprudence positioning system, direction on, has been making it to some of their desks and emails and maybe even their large language models. You know what I mean?
I think you're onto something.
And I'm telling you, it was a whole different. Like I said, not only could I feel it, but I could hear it. They just didn't have that smug arrogance in their voice or presentation. And a lot of the even when they took questions from other attorneys, I guess that was in their chat on their Zoom that they were having, the guy was like, what you need? The guy was like, yeah, don't be afraid to ask your questions, even if it's embarrassing for your career. Like, it's okay. There's no embarrassing question. Like, I've never heard you say that before, attorney guy running the Zoom. So, pardon my sinister laugh, but it's necessary.
No, it is absolutely necessary. It is absolutely warranted, because as we've been realizing over the last half decade at least, is that these attorneys we perceive them as being like abnormally intelligent, like, supernaturally intelligent. We perceive them as being learned in the law. Then we start educating ourselves about the topic that we think we're going to then have a discussion with the attorneys about. And when we start talking to them, we realize they don't even know what we just read. And perhaps we are, it's on the top of our mind because we're fresh. We just learned it. We think they went to law school. They've been practicing law. We're supposed to have an educated conversation. And then it's not an educated conversation. So now, with the addition of AI to help in research and development, we are exposing them. So some people say, oh, well, they know procedure. And again, we learned the procedure. We start looking at their cases, guys. We start looking at their what they're writing. I hope, well, I know this is Newbie Tuesday, but it's not everybody on here is an actual newbie. And we're recognizing that our documents are better than some of the attorneys' documents that we had been going over for years.
That's a fact.
You look at some of the attorneys' paperwork and you're like, wow, my well-trained bot did better than this attorney. We are the ones catching them in their procedural irregularities,
using templates that they use. That they always try to say
boilerplate, which the bot recognizes and calls boilerplate.
Right.
Mm-hmm.
And tells us
every
to
argument
object to
imaginable.
their boilerplate responses, especially when it doesn't reflect what the points that we were actually saying or making. Is just they just come out of their behinds with what they were used to hearing with the old school pro ses.
Indeed. So
We should
with
respond with, I don't know what this means.
Everybody's the same, or they could just smack us around like they've been smacking cats around, perhaps.
Well, they get by with
intimidation.
They get by with intimidation, kind of like when you're going into a fight, like it's boxing. You get intimidated by the shit talking of your opponent, right? It gets in your head. Anybody know what I'm talking about?
Yes, absolutely.
Mm-hmm.
So if the attorneys have been getting into people's heads.
Sometimes you got to promote a fight with a press conference to get the sales.
What? Ty says, I've got attorneys with 30 plus years turned judges making open procedural irregularities, either mistakenly or intentionally. Absolutely. Absolutely, Tice. Yes, does sound like a narcissist. Narcissists are attracted to positions that give them automatic a higher social status. Did you guys notice that? They love the automatic higher social status positions.
Absolutely. And I have a theory that schooling, especially institutions of higher education, they are breeding people to be like that. All the people who are going to be the attorneys, the judges,
yes.
They give you, like, I remember being in college, they like amp your brain up and give you this almost complex of like, you're smarter than everybody else. So you should be in charge.
Yeah. Yes.
I guess I'm a narcissist then.
What's up, McReal? Oh man, did y'all see what Hassan had on the screen about the attorney slapped with record fine after citing case law hallucinated by AI? This is happening all the time. There was another, at least two other cases last year.
They're the
Anybody
ones who put
remember?
it. They're the ones who put it out there.
Yeah, Liv shared it. That's why when I saw it, I was like, So Liv was like, on that note, and I was like, on what note?
How much was he charged? The other dumbass was charged $5,000.
Let's see. And this was what, the 26th?
Yep, days ago.
Jesus, Mary and Joseph, right? Oh, it was updated. It was published on the 24th. Okay, at 2:43 p.m. Salem attorney Bill Giorso speaks before the Oregon Court of Appeals in November 2025. That's
Oh damn,
screenshot.
and he a neighbor too.
Another Oregon attorney has been bamboozled by
Another fucking one. This ain't the
Bamboozled.
first
Wait,
one.
wait, wait. How are they talking about he's been
because
bamboozled by the AI?
they're trying to
They're
blame.
faking it. That's a pump fake. Because if they're the ones who put that shit out there, he ain't in no trouble.
Listening to drunk AI bots.
Again, remember, for me, this is a ploy to try to get large language models stop being used, okay, by pro se litigants. Because imagine we're all contractors, we all build houses,
How
right?
the hell are they gonna know? How are they gonna stop us? What you gonna do?
Yeah, but it's like,
how are you gonna put the genie back in the bottle?
Break it.
Since the common people that are contractors have access to power tools now. Those that been had access to power tools, like they're using power tools to build houses too, and we can't sell any houses now. Like what? Stop it! Stop your clock bitching in the morning.
They issued a what? I can't see the amount.
Oh, sorry. Let's do this. Let's turn it back this way. 10,000. A Salem-based civil attorney, after determining he signed to a legal brief containing 15, not one, not two, not 10, but 15.
Oh
bogus
my God. You didn't check any of them? What happened to your paralegal?
Quote that had been contrived from thin air. Hey, let me ask a question. How many of y'all state remedies or jurisprudence gem is hallucinating? None is the answer. But always triple check it, like I always say. Like Malika says, like any of us say, always double and triple check when you're using your digital assistant.
What 15? What happened to his paralegal?
What's this? Is the advertisement? Get off my screen.
What happened to his paralegal? Why 15? 15 bogus citation and 9 quotes out of thin air. 9 quotes.
But you guys realize
we're kicking there.
You guys realize the failure to conduct pre-filing investigation or post-filing? I'm saying pre-filing. Go back to that line. Go back to after signing, where it says after determining he signed his name to a legal brief, signing and pleadings by attorney. This is pre-filing investigation, right? Failure, or at least along that construct. Who may agree?
Oh, my question is who put it?
I absolutely agree.
My question is who put out fake cases? Who does that?
It's the failure to investigate whether or not the case cited were accurate or relevant.
I'm saying they're doing this shit.
Yeah, so they're getting caught in their own net. They're putting out fake cases and getting caught in their own net.
I mean, we wouldn't put out fucking fake cases. Come on now.
So when I can tell you I use Copilot, and there were sometimes Copilot thing, and before I submit the document, I went and checked all the court cases, and all of them were wrong. All of the court case decisions were not, and some of them didn't even exist. So
Well, that's what happened with this fool right here, and he still put it out instead of double and triple checking it.
And I'm not even an attorney.
They're all fake.
That part.
They're all fake cases.
Right, even the ones you can find.
Yeah.
Hashtag facts. I just heard
They're all irrelevant.
There he is.
Let us read
Okay,
this
let's see
paragraph
what else.
carefully.
What
It says
else
the
is it saying
Oregon
here?
the Oregon Court of Appeals issued a $10,000 fine. Right after
Diorso
am I being heard?
the fee.
I can hear you, but I don't think Seven can hear you.
I hear you, Trading. I don't know if Hassan can hear you.
I don't think Hassan can hear. He got a lag or something.
I'm just asking for us to read that part again, Hassan. I think we missed it.
Scroll back up again, like 2 paragraphs or 1 or 2 paragraphs.
Because they relied on the fact that he signed his name to the brief.
Yes, I definitely heard that part.
Rule 11. I'm not sure if every one of us able to identify that.
I heard it the first reading.
The Oregon Court of Appeals issued a $10,000 fine to Bill after determining he signed his name to the legal brief. Absent signing, would he have been able to the fine be binding?
No, because he didn't sign himself or hold himself to it.
So I hope we can see the importance of the
pre-filing
investigation.
Absolutely.
The pre-filing investigation.
You can't say, well, I'm going to go check with my client if those cases are fake only after you challenge me about their fakeness. Oh, I'm going to go check with my client.
The signing is Rule 11.
Doesn't Rule 11 begin with by signing? Isn't that like in the first?
It says signing and pleadings. Let me pull it up.
That's what I'm saying.
Can I share first whenever we go to the sharing part, please?
It says signing, pleadings, motions, and other papers, representation to the court, sanctions. A's signature. Every pleading, written motion, or other paper must be signed by at least one attorney of record in the attorney's name. And that's why they were able to actually fine Bill. Or what is his name? Yeah, Bill. Bill was presented a bill.
You mean the e-sign?
Huh?
No, it don't matter if he e-signed or real signed. By having your signature
it was determined. It was determined that he signed his name to a legal brief, and that's the fact.
Let me make sure I'm good over here.
We can hear you too, Hassan. McGarvey. Yeah, go ahead with your story, bro. Especially if we're done with this, unless somebody has a question, comment, emotional outburst.
Okay, so I went to the dispossessory hearing this morning, and the judge called me a sovereign citizen. Let me check this Rule 11 real quick. Okay, so I went earlier. So when I got there, it wasn't the attorney of record. Melanie Boyd, who was supposed to represent Allison Painter, who never sent me her delegation of authority. She was the one who was supposed to be present, and she never showed up. So afterwards, when I seen this guy who's saying that he was on behalf, I asked him if he could provide his delegation of authority or anything of the sort that shows that he could show up and answer. He says that he wasn't going to answer me. I asked him for his name and bar number. He didn't answer. So apparently, I don't know what happened. They said to go out by the clerk's office or wait outside of the clerk's. And I guess that was for mediation, but they never called us into mediation. And then they went into, or they took us into a place where we had a judge that was there. The judge, I had asked the judge about the delegation to show authority from the original attorney, from this new attorney, also about capacity. And he said, it sounds like sovereign citizen talk. And he says he admits.
Where's your delegation, motherfucker?
Well, that's what I was thinking. So he had admitted everything I said over objection. So then I had it recorded and I just wanted to play it for you so you guys could hear it. What
Yeah,
happened?
let's do it.
Okay, hold on.
Is, and the dispossessory filing itself and all of the occupants. I'm not exactly sure, the relation, of the defendant in this particular case, Your Honor, with respect to the property.
What standing do you have?
Am I allowed to know his name, Your Honor?
Yeah, my name's Justin Bennett. I filed an entry of appearance in this case, and
Okay.
I've had.
Can I get a copy of that?
Federal Loan Mortgage Corporation, by through Alice Payne Rattery to enter into this, in this proceeding today.
Can I please see a copy of that entry of appearance?
It's in with the court's file.
Court, can I see it, please, Your Honor?
Look at it if you want.
Yes, please. I'd like to see it.
I don't know what is your.
I would like to see that entry of appearance so that I know.
That he is authorized to practice law and to represent this company. Now move on.
So just so I understand, you're saying that I'm not allowed to see the entry of appearance?
You should have been served with a copy.
I was not served with it. Did you serve me a copy?
I did file it today, Your Honor, in the court this morning. It should be.
The question was, did you serve a copy? It's a yes or no.
You're doing so good.
Hold on. Did you see what he said? So he tried to dub me because the judge was on his side up until that point. So he said, oh, I'm not going to go back and forth with you. And then the judge hopped on his bike. Let me run it back.
Dude, this is really good work in there, McGarvey.
Thank you, bro.
Word.
Hold on. Did you serve him with a copy or not?
Now, I did not. I filed the entry this morning and submitted with the clerk's office.
I did not.
Wow.
Get a copy and serve him with it.
Because I filed it this morning.
Because I filed this morning. Shut up.
5 minutes ago.
Shut your bitch ass up.
Do they know procedure or not?
Hell no.
Hold on. Are you about to hear the best part? Hold on, guys.
Continue this case for lack of service. Now, you're an attorney. And you should know that when you file something, you need to serve the defendant with a copy of that.
Does that sound like bad faith? Did you just explain bad faith, Judge? I don't know.
Was it his first day?
All this has been a waste of time because
Don DeMarco.
100%.
Hold on. Did I just hear I don't have jurisdiction? You wasted my time type shit?
That just sounded upset right there.
You should have seen his face. I wish I could have been there.
You did? I thought I heard due process in motherfucker.
That's what I heard too. I'm just saying. So, and honestly, guys, let me just be completely transparent with you guys. I was not like fully prepared. But I knew that I had.
I couldn't tell with them awesome questions you were making.
Exactly.
Okay, yeah. So the reason why I wasn't prepared is because I had filed the answer, and I guess the list pendants that I had wasn't the official list pendants from the Superior Court. But I told the judge when I was there, I said, I don't, if I go ask them, they're gonna try to charge me money. You know what I'm saying? So, but he ended up calling the Superior Court clerk, and I guess they told him that there was no list pendants, and I went to go check and there was, but that's a whole different thing. But anyway, the judge was perturbed, even though he was trying to dub me. And then the guy, I'm gonna share my screen so you guys can see.
Dismiss.
So they had the continuance because I had the original request in my answer about the authority, how I wasn't a tenant at suffering as defined in law. The tenant at sufferance or the position that they're asserting would need
not that you are or are not,
right,
but that the record
does
not reflect any definitive answer to or any and support to their allegation. They have to prove every single element. How are they going to prove you're a tenant at sufferance or any other kind of tenant without anybody with any firsthand knowledge of anything?
They can't. They cannot.
And remember, I know Trading Brigade is going to know the case off rip, that they are not if they're just signing, if everything in there is just signed by an attorney, that is not evidence.
Correct.
Everything just can. It's not verified. It's hearsay.
Hey, I'm listening to you, McGarvey, and my issue, not even an issue, but what I like the most about your case, there is no landlord-tenant relationship, and a dispossessory action is not the proper remedy.
Exactly.
Dispossessory action does not lie here. It's not the proper vehicle to at least cause them to regain possession of the property because they never had possession in the first instant. And second to that is the same tenant ad sufferance. Even if you were to be a tenant ad sufferance, a dispossessory action is not the correct application.
Did you invite anybody else like McGarvey to that document where we went over that and the definitions of the tenant and sufferance and stuff?
Which one is that?
The one where you did the research about
no, he's not added to that document.
And the fact that ejectment, guys, just so y'all know the term, and Keith has said this shit from 7 years ago. It's ejectment that they're supposed to be doing, guys. If, let's say, there's no landlord-tenant relationship, which in many cases of eviction, there isn't any statutorily legitimate landlord-tenant relationship, especially when it's the post-foreclosure.
But
there is no landlord-tenant relationship, and that just kind of goes out the window. That's not an argument that people stickle on. Go ahead, bro.
No, I'm saying even if it's a post foreclosure, it's still not related to the brother here that the case was brought against.
Correct. And I'm just saying, in general, it's not.
Let me ask you a question. So that's pretty interesting. I didn't know that. So, like with the foreclosure, you're saying at that point, the relationship between you and what they're calling a tenant relationship, or what we think of, it's already over. You're saying it's already been dissolved?
No, it doesn't. It hasn't been proven to exist. It's never been proven to
according to Georgia law, it is without question that there exists a landlord-tenant relationship, and that landlord-tenant relationship must carry at least a grant and an acceptance of possession, and that cannot be found anywhere on the record as far as the facts are related to McGarvey's case. There was no grant of possession from any person. And neither was there any acceptance.
Eviction is only for a landlord-tenant relationship. If there is no landlord-tenant relationship, the correct process to remove somebody is called ejectment. And they never file ejectment. The attorneys do not file ejectment because it requires them to prove things that they cannot prove. So what they do as a tactic is abuse the process of eviction, aka dispossessory or unlawful detainer.
They turn it into Stretch Armstrong, trying to stretch it to fit their whatever they want it to fit.
They just abuse process straight up. They just say that it's a landlord-tenant relationship and just claim that you're either a tenant at will or a tenant at sufferance without proving it, because they're using or abusing a procedure that presumes title is vested within the state.
And they're hoping you are not a member of Lawful Living to hear this.
Facts.
Exactly.
Facts. I can attest to that.
Gratitude, bro. That main part right the fuck there.
That is it right there.
Y'all stay not inviting anybody new to this call so that more people are aware of this. Y'all stay keeping it a secret.
I'm not. They think I'm crazy still, so they gotta see me keep doing it, and that's okay. I'm gonna keep doing it. They don't gotta show up. I'm gonna show up.
Who's trying to take it from you?
Attorneys, as usual. It's always these attorneys don't never have no client. Can we just say that?
Though? Were the attorneys hired?
Say that to all the newbies here today? In our experience, these attorneys are who's coming after us. This is why the very first class at Lawful Living is called Beat the Bar. And if you're new here and you've not yet taken it, you need to take it. Take both the original and the 2.0. The bar is the only problem. the only thing the bar does is put somebody else's name as the plaintiff, so you get thrown off about who is actually coming after you. It is always that. I don't care what you think the controversy is. Credit cards, child support, custody, any kind of debt, mortgage, eviction. It is only and exclusively the attorneys. Because if it was anybody else, why wouldn't they have their delegation of authority?
Boom, boom.
Why wouldn't they be able to prove on the record that Citibank sent them, that whatever LLC sent them, that whatever Inc. They don't have nothing.
Them not have it.
Them not have it.
So in McGarvey's case, the attorneys act like the in-law are trying to take possession.
That's every attorney in every case.
Thank you. We have to realize that McGarvey's situation is only highlighting. It's always only the attorneys. This is why we're kicking their ass with the Rule 11. This is why we're kicking their ass with the good faith. Where is your fucking client? Where is your client? How prove that they're your client? Prove it.
You mean there's no real party in interest?
Correct. They stay violating Rule 17.
Where's your Messiah now? Yes.
So I don't know if it's the correct form to go over this, because this is kind of not newbie stuff. But this is what I had, and he really didn't. The judge basically went through this whole thing and said, "Yo, all of it is bogus," and then he let the attorney speak, and then he was like,
"Well, how many pages is it?"
It's 1, 2, 3, 4.
Too many.
Okay, yeah.
8.5 by 11.
1 page focusing on the lack of standing for no real party in interest and no proof of delegation to act on behalf of anybody who is a real party in interest.
Those things go hand in hand, y'all. Hope y'all listen.
So you just need a sniper rifle. That's it.
That's my favorite.
Don't eliminate double spacing and don't write in 4 font. Keep the argument singular. Standing.
1 page for lack of standing and for no real party of interest.
Yeah, those things are hand in hand, like Hassan just said.
Okay, correct. Yeah.
Standing is one, a real party in interest, and 2, a delegation of authority from that real party to the attorney that's showing up. Does everybody get that?
If one has standing,
board of directors.
If you're saying you are the one that has the right to enforce, then present us how.
Correct.
That's it. Just show
the
us.
The record doesn't reflect.
Show us who gave you the green light, and then we'll go, okay, all right, now let's kick your ass from another angle then. You did show it.
Because we still got the real party interest. So even if they have a delegation of authority, whether it's some type of board resolution or some other alleged authority from who could hire them for litigation, let's say they got that. That don't mean that they're the real party in interest. And that's why they go hand in hand. The real party in interest, number 1, has to give the delegation of authority, number 2.
Yeah, and because the mirror says there's no reflection. Damn.
Word.
So this is the bar information for this guy. If anybody wanted to do anything about that, I'm gonna do some stuff, but you know. So that's what I wanted to share, guys. He gave me that. This is what he didn't serve to me. And then the judge had a continuance, but I'm going to tighten it up, of course, because.
Did this attorney get their good faith?
No, this was not the attorney. I'm saying this somebody who showed up. I didn't know.
I got you.
But yeah, the other attorney that was on record.
Somebody from the same firm? Because
no.
I'm thinking it's a different attorney firm.
He said he was a subcontractor. That's what he told me.
What?
And when I asked him for his name, he didn't tell me. I asked him for his bar number. That's why I asked the judge, am I allowed to know his name?
He's scared of you.
It's probably local counsel that they've
hired.
Somebody's
scared of you. Because if he's a subcontractor, Now you the secretary's motherfucking secretary. You got to show delegation all the way from you to whoever gave it to you to who gave it to them.
Is that
But a
chain
lot
of
of times on
custody?
like credit cards and different like these banks and stuff, they'll
wait a minute. Wait, before you say that, I have to interrupt you.
Go ahead.
Do you guys see the procedural irregularities going on here? When does an attorney ever show up and say, I'm not the attorney, I am a subcontract? When do we ever see this? Where have you ever heard that?
And then he says, and then on top of that, he says he can't give me his name or his bar number on top of him being a subcontractor.
But now you got his name, which can lead you to find his bar number.
Yeah, I got his name in his bar
number. And that's why he didn't serve you in the first place.
Because he doesn't want to get his own good faith attorney notice. Do y'all realize that?
Exactly.
Because that's what I was saying. Like with these banks, a lot of times they'll have a bunch of cases. Like say it's a firm up in Chicago. Well, they don't want to go, to downstate Illinois to one day of this week to do however many cases, credit card things that they have in that town.
Oh my God!
So they'll hire
the law is inconvenient to you. Is that what you're saying?
I'm assuming that's what they're doing. Because they'll hire somebody from that town, to go in there and basically
following the law. It's so uber.
So let me throw someone else under the train and bus as opposed to myself.
Exactly.
Oh my goodness! Oh wow!
Exactly. There you go.
You wasted my time because you didn't do your job.
And now I'm spitting skull all over my gavel. That's how
this was after like a long wait time. So everybody, newbies especially, I encourage you that if you have maybe anxiety or anxiousness, that you figure out a way to be able to return to center, because everything within me wanted to go out and do something. I was getting upset and blah 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 blah. But you have to remain steadfast on the point. So the judge did the very best, even insulted me, called me some word I don't even know what a sovereign citizen is, but he called me that. And so I could have let it throw me off, but you have to remain steadfast on the position and you will get the results. And I literally recorded it for you guys and I shared it for you guys. So remain calm.
Amazing.
Don't be, because the last time they did this already and they actually didn't show up the first time. And so I didn't know anything, and I was ready to just blow up. And then I was, but you can't really address it like that. So try to be calm as you possibly can.
So y'all see what's happening in McGarvey's case. First, the attorney doesn't show up. They fail to appear. Okay, they get an extension. Now this is the extension meeting where they get another extension. But now this attorney's going to get his good faith notice as well. Are they going to then subcontract the subcontract?
Because all they're trying to figure out is how to get him out of there, like the movie Accepted, where they were trying to get them out of the college that they made for themselves, right? And then it went to trial, and they got to keep their college. And I'm telling you, that's what's about to happen. You're about to not go anywhere, bro. But they're trying to figure out how to remove you. But again,
well, how are they gonna prosecute by ambush?
To play with your food a little bit, bro.
Exactly.
Hold on. Send the good faith notice.
Uh-huh.
Right, on the attorney's authority. File a motion to dismiss, and if the court refuses to dismiss, give an option to exercise the rules of the magistrate court 40 to have a pre-trial discovery and set a hearing that the attorney would provide his authority to represent the plaintiff.
That's the UMCRs that he's talking about, bro.
The Uniform Magistrate Court
Rule
rules.
40 pre-trial discovery in lieu of
a dismissal. If they to dismiss the case, or if
in lieu of the dismissal, if they don't dismiss, then have a Rule 40 pre-trial discovery with their authority.
Yeah. On the grounds that there exists no landlord-tenant relationship too.
Yeah, why not have the limited discovery? Because then that way you can have them bring everything that they supposed to have that they don't. And then they can embarrass themselves even further for not bringing credible evidence before the court of a document showing that they can do what the fuck they trying to do.
If he sends those things off today, tomorrow, anytime before the case, they're not going to show up again. Because they already passed the buck. And I don't know if this might be going over people's heads, guys, but y'all need to realize this is not happening in other communities. This is not happening where they substitute the attorney and then the attorney is scared to tell you their name and give you their bar number. They're usually very proud to be like, yes, I am the one kicking your ass. I'm so-and-so from so-and-so.
I'm an esquire.
Yeah, doing what trading is suggesting though, it's also pressuring the judge, and the judge will have to step up and either dismiss the case or make the contractor produce the delegation.
Because if the judge would issue a judgment in that case, that's a reversible error upon appeal.
Exactly.
Upon appeal. So you're protecting yourself from this level up.
And putting the judge on the hot seat. That's what I like that strategy, because the judge already tried to insult you by saying you didn't know what you were doing by calling you a sovereign citizen, but he's looking at the facts of the case and he had no other way to go but to tongue lash the contractor, knowing that he's there as a contractor and not even the damn attorney. To me, right there, he should have just dismissed the case. He didn't have any jurisdiction anyway.
So, Training, can I ask you a question, bro? Do you see here? This is the attorney of record allegedly that still didn't show the delegation, but it was never approved and the deputy clerk never signed. Would this be a solid or a valid affidavit, or am I missing something? Because I try to argue that this wasn't valid, but maybe that's not a point.
And I think you got more meat than that you could chew on, bro. Not saying you should overlook this, but
yeah, he got a lot.
I'm not saying you should overlook this. I'm sticking with the issue that based on the juncture of the case now and what you have mentioned, since they would have failed to at least make appearance prior to this hearing, that's even more reasonable ground to demand a pretrial discovery according to the Rule 40.
Okay. Understood.
And dismissed because there is no landlord-tenant relationship that can be found. There was no grant or any acceptance of a grant of possession of the property that is associated with this case.
Okay.
And with that being laid out, the judge is not going to call you a sovereign citizen after that.
Man, don't. I don't even want to pay that in mind. I'm not. I don't even want to.
Okay, can I? And then, okay, so another question. So there's also the list pendants for the Kia, however you say it, time it action. So that's also a something I could use as well, but I would have to get a certified copy from the clerk. There's no other option, I assume.
Well, what's the purpose of the list pendants in this matter here now?
Because if the list pendants is regarding title, how could they adjudicate a dispossessory action? That's kind of what
I've seen they've done it.
It's irrelevant. That's why they're abusing the process of
don't pay attention to that list pendants right now, bro. Okay. Don't pay attention to that list pendants at the moment. I'm sharing with you what I think you should do, and you could go and do further research also.
Okay, I will. Absolutely. I'm gonna do that right now when I'm done. I appreciate y'all. I don't want to take too much time, but I was very excited. I wanted to share, and I love y'all.
But reach out and I'll share some stuff with you, bro.
Okay, I will.
Can we listen to that one more time?
Say it. What'd you say, Jay?
Can you ought to put that back on. Let's listen to it one more time, all the way through.
If we have time, or do we got time for that, or not?
Was you posted on Lawful Living?
Yeah, I can. I just need to figure out how to upload the voice, and then everybody will have access to it. So I'm gonna do that.
Okay, maybe if you do it through Google Drive and then post the link.
Okay, perfect. I'm gonna do that right now. So
you got an upset stomach from that.
But that's all I had, guys. Love you. Thank you guys so much.
Awesome, McGarvey. Gratitude for sharing. I hope you guys got value out of that presentation and conversation.
Word.
Yep, you didn't keep quiet. You're speaking up.
I'm still in awe that attorney was like, nah, you can't know my name or my bar member. And then say I'm the secretary.
I'm the secretary.
I don't know if y'all got over that, but
you know how they give you that little time. They said, okay, well, 2 parties are here, then you guys could talk in the hallway. So then I asked him, I was like, what's your name? He's like, I'm not gonna get into that right now. And then so he sat down. I said, yo, can I get your name and bar number? And he was like, nah. So then what we got in front of the judge. I had to do my dantata, but that's from being around you guys. So I
You
thank
did
you.
it the
Thank
right
you.
way by asking it in open court, regardless of what they told you outside. You did the perfect thing by saying in front of the judge, because why would they withhold that information if everybody is if supposed to be up front? And then he lie when he said that he entered an appearance?
I'm willing to wager that he did because he only filled out that appearance that I showed you guys with his name and bar number right there. And so,
after he said on the record that I entered appearance this morning into the case,
there was no clerk in the courtroom or anything. It was just me, him, and the judge and two deputies. And then,
but he said I entered an appearance. Did y'all hear that?
yeah,
Am
he
I the
did
only
say that.
person who heard that? Okay,
Yeah, no,
because
he
I
said
heard
that.
I
Definitely
entered
said
an
that.
appearance this morning. Did
Yeah,
he
but he said he
actually
didn't
enter an
serve it.
appearance?
I'm not sure. I'm not sure. He didn't give me no paper this morning. I was there the whole time. He was there, and he didn't give me
Yeah,
nothing.
but is it on the record? What does the record reflect?
Oh, I don't. I asked the people for the whole docket, and they said they was going to charge me. So I asked them to email it to me. So I'm waiting for the email.
If there is none, that sound like clear
But you
violation
can
of
view it.
3.3.
Was it Zoom hearing?
No, it was just in person. So I had.
Okay, listen to me carefully, everybody. When you physically go into a court, you can look at the docket with your eyes for free. It's the copies that they charge for. But visually, you can open up the folder and read what is in it. You can know.
What about a PDF? Like whenever you email them
Guys, this is why they make you come to court and file live. Don't you understand?
Well, I mean for copies. Like I've called.
I don't care nothing
them.
about that. But when you're physically in there, we're not talking about copies right now. Does everybody understand that they have the right to view the file for free, the actual physical file? It's only copies that cost that they charge you for.
Word to the big bird. You heard.
Yeah, that's correct because I did go to the Superior Court to look at the quiatimement, and they let me see
Exactly.
the
You can
copies.
see it.
Yeah.
Exactly. It's same thing. Don't let them tell you that they can't, that they have to charge you to view it. So you should have the answer to this question already.
Yes, you're correct. I should, but I did not do it at the time.
All right. Make sure you always know what's on that docket.
Yep.
And if that attorney lied and he did not make an appearance, or he's asserting that his mere filing is to be constituted as an appearance, I mean that's questionable as well. But that might be what they're trying to refer to, like, the thing that I filed, that's what gave me or is entered as a appearance. But find out.
Yes, I would really research because that would be a violation of the local rules of the UMCR. I forget which particular section it is, but it would be a violation as well as a 3.3, it appears, though.
What specifically would be the violation?
Not the failure to make the appearance, enter the appearance.
Is a filing considered an appearance? Would his filing of whatever he didn't serve be considered an appearance, pursuant to the rules?
It could be.
What is it? Isn't that he failed to? He said he made the appearance, right? But it's not confirmed if it was made because the brother just said it was filled out that this morning inside the courthouse. That's what he said.
Unless he's talking about the filing that he did not serve on him to count as an appearance.
Well, that's the one I'm talking.
There's some jurisdictions that count a filing by an attorney, signed by the attorney, as an appearance.
Well, no, it talks about appearance independent in the Uniform Magistrate Court rules for Georgia.
Okay, great. That's what would make the difference. Awesome.
Well, that would be called an answer, but you didn't get it. And I see people that are winning cases, they're sitting there with the records, the folders in their hand, thumbing through the paperwork.
Well, that's why it's important to make sure that if the rules say that an appearance must be entered, and it also says it also counts, maybe, that a filing from the attorney counts as an appearance, that's cool too. But do your best to hold their feet to every flame in the fucking fire, please.
Well, we wanted to use that against them as well because that's their rule.
And when the judge tries to say that the request for the attorney's authority it is a sovereign citizen or any disparaging thing objects to make them cite the rule that says that asking for the attorney's authority is some type of offense or something negative. And of course, having your back pocket the rules that say that an attorney appearing must have the authority.
Did y'all just hear Malika what she said?
And that you have reasonable grounds to suspect it's not being prosecuted or defended by somebody with that authority.
Hold on, rewind on that. She said, ask them for the rule that they're citing, as well as have that rule in your back pocket so that you know when they say some bullshit to you, you can be like, oh, really? Well, because right here in section whatever it says, you know what I mean?
Indeed, that's why I said I wasn't fully
The
prepared.
other thing is, I know I'm interrupting you, but the other thing is, don't let them conflate your question about the legitimate authority for this particular case with if the attorney is in good standing with the bar, with the state bar, because those two things are not the same. They can be in perfect good condition with the bar and still not be hired by the proper authorities. That's how we're going to say it. By the proper authority in this business or corporation that they're claiming to represent, which absolutely is a threshold issue. And it would be a denial of due process. Intentional, especially if they're calling you names, it would be a denial of due process. And in my opinion, obstruction of justice.
No, I was gonna say, so like reasoning from the original delegation of authority that I never got, whenever this new guy showed up, I'm like, okay, well, you still need that delegation of authority, which is why I reasoned that in the court. But while I was waiting, I did was talking to the bot. I'm like, yo, this guy's showing up. He won't give me his name, his bar number, and it was like, yo, he has to have a notice of appearance, and that's why I was pushing for that because it's similar to the delegation of authority. You still have the ability to be there, but the judge, for whatever reason, until
it absolutely is a form of delegation. Same thing with a retaining agreement. Same thing with just powers of attorney. Though that is the delegations.
Word.
Yeah, and so the judge, for some reason, until like I was able to speak about just knowing him, because he, like, when I gave the answers, I had said all the delegation stuff, but he wasn't jacking it. So when I'm like, I don't even know this guy, that's when he went for it. But I'm definitely gonna be more prepared for next time, and I'm looking forward to what did trading playing with my food. I'm gonna reach out, trading.
So I do have a question.
Go and ask it already. Nobody objected.
Go ahead.
Okay. Okay, so I'm still dealing with the water people, and they sent out an agent to my dwelling today to terminate the water service. So I reached out to them via phone, and I did record a conversation. And the agent on the other end from customer service said that everybody has to pay the water. And so I was in communication with Miss Williams prior, and I said that I spoke to one of the agents and my questioning has still not been resolved. However, water service to my dwelling was disconnected at sometime around 11:20 today. And so she was like, oh, well, I don't see anything here in the notes. And I said, well, you could ask Miss Williams. She was like, okay, I gave her all her information. And she said, well, she didn't communicate anything to us. No correspondence is there within the system. Long story short, I was doing some research and trying to figure out things to support or rules to support my claim, as previously mentioned today. And in that research, I found chapter 373 .016, declaration of policies, because she was saying that it's within their policy rights to terminate for non-payment, and that everybody has to pay for the water service. So I went and I found this.
Wait, I need to know where the definition that includes the word everybody is.
Yeah,
in
exactly.
any statute.
Yep.
Yeah. I mean, as you guys know, I've been taking a swing at this for quite some time, but I ain't got no water again. So
did
now,
they use the word everybody?
Hold on, let me pull up the recording real quick.
For having service, so let's say you go on vacation, don't only help out if you're. It's not a permanent thing where they'll pay your bill every month.
Okay, thank you for that information. So basically, the fee is associated with the use of the water.
Correct. You pay for the water used, and there's fixed meter charges for which is just the service, just for having service. So let's say you go on vacation for a month and you don't use any water, there's a small fee for having an account with us. But that is everyone. It's not limited to any specific person. Everyone has that fee.
Okay, so okay, and I'm not trying to sound like a bad person, but like how do I gain access? Because she keep mentioning like, okay, the Florida law, the Florida statute allowed you guys the Orange County ordinances, but I was just trying to gain clarity. Where do I find that? Like, what specifically says that? That's all I was trying to ask.
Yeah, so I'm not citing any statutes. I'm not a lawyer. I don't know the statutes. What I'm explaining is Orange County utilities policies and how it works having an account with us. That's what I'm explaining to you. Now, if you're looking for legal explanation, that's something that you'd have to look into on your own. But
no, I was just. So you see, like I'm trying to ask, like I've been trying to ask multiple different agents within the Orange County utilities for clarity as to where they're getting the rule that they're using. That, as she says, everyone. My correction, not everybody, but everyone or everybody, as you guys heard in the recording, is responsible for payment for their water service. And
she's saying that I'm not quoting the statute, I'm quoting the policies. But do you have a written policy? Did you get? Can they point to the section in the policy that they're talking about?
I mean, I've been asking and nobody ain't
point me. When she said I'm not quoting the statutes, I'm quoting the policy, did you confirm? Okay, well, show me the policy that says that.
Well, later down in the conversation, I told her that I was in correspondence with Miss Williams trying to get that information. So
yeah, but the policy, since they want to say, well, I'm not quoting statutes is for attorneys. Wonderful, you're saying policy. Let me get the policy. What page is that on?
Okay. So I asked for.
Am I making sense? Not just for that information. Clarify, because they're clarifying. Oh, I'm not quoting anything from the statute because I'm not a lawyer. Wonderful. You're claiming the policies. Show me where in your policy is the word everyone. Because I bet you in the policy it's going to use the same definition in the statute of person.
Okay. And then I was doing some research, and I don't know if it's okay if you could pull it up for me, please, Malika.
I can't pull anything up. I'm sorry.
Okay. It's 37. Well, I can show it from my screen.
Once you tell them you're not a person, they're gonna hang up on you.
Let me start the video again. Let me turn. Okay, so it's chapter 373.016, and it's under declarations of policy, and it says the water in the state are among its basic resources. Such waters have not hereinfor being conserved and fully controlled as to realize realize their full beneficial use. So based on that, I was saying there was nothing within that particular policy that was stating that for the basic resources that you have to pay. It just says that it should be conserved.
It all depends on the definition of you. If you are using the water for your business opportunity, then you are responsible because you are using it for business. You are charging people because you are running a stadium. You are running a restaurant, etc.
It all depends on what the definition of is.
So a good way to address the supervisor would be to ask for
go to the policy. Let them show you the section of the policy that defines who is the you that has to pay, because them saying everybody, that says that there's a word saying everybody, and I've never seen any policy or statute that actually uses the word everybody. And if it were everybody, why would they have a definition of person that doesn't just say everybody using the service? Never gonna see that.
Okay.
And I'm open for correction. Anybody that wants to chime in, anybody, I know it's newbie, but let's get it.
Is it my go?
I was just waiting to see if anybody else had anything to add.
Do they have to define person in their policy as well, or is it going off
That's
the
why we
same
got to
statute?
look at the policy. We got to
ESV?
find where the policy is, because they're saying that they're explaining the policy. Oh, we want to see it. Where is it at? Where's the policy? And then where in that policy does it define who is the everybody? Or is it presumed? Because that's going to be a problem. And that's why to use whatever declaratory order, declaratory relief, if you want to call it, declaratory action, whatever they got, that's declaratory. That either there is a definition and they're misapplying it, or there ain't no definition and therefore you object to the application without a specific definition that includes you.
Or it could be latently ambiguous.
Exactly.
The definition that's according to the account or the contract taken in consideration and measured against the definition of what the statute says. That's where you look up the term latent ambiguity.
Thank you.
All right. Who asked if it's their turn to go?
Me, Elijah. Excuse me, y'all. Excuse me. I'm coming through. Pardon me. So I'm coming with a success story today from yours truly.
Make sure y'all hashtag success story.
Hey, have my back like chiropractic class. That's all I'm saying.
I love you, man. I love you, baby. I love you,
So
love
I
you.
had my attorney's mediation. You know I'm an attorney, so I had to mediate with the other attorney today, and they was trying
Look
to
at
give me
you
the time.
looking sharp in your attorney suit, bro.
I made sure I came in.
Yes. More fire, more fire.
I came in looking like a disco dynamite in that joint today, but they knew I wasn't playing. So I did a mediation, right? And the mediation, they wanted me to sign a paper. I was like, I'm not signing that shit. So they immediately, no mediation. So we went in front of a judge. We had trial today though too. He was like, the judge said that up front. He's like, well, we're gonna have a trial today and whatnot. So I'm looking. First thing I noticed, nobody from the building here. The attorney, Mike Williams, not here. The designated
What?
agent not here.
What?
Nobody here.
What? The plaintiff did not
Yeah.
appear yet again?
Yeah. So they had somebody else from the firm, and I found that out. Like McGarvey said at the last minute, because otherwise I'd have sent their ass something. I ain't find out till day of. She came. She's like, "Oh yeah, I'm Ms. Lewis. I'm representing. I'm on behalf of the client. I'm the plaintiff. I'm coming through the counsel though, like of the same plaintiff." I was like, okay. So from there, like the judge let her speak. She didn't have no evidence to present. When I say she didn't have no witnesses, the judge Trader McGay said something about Rule 31, and like that's about like that the uniform Rule 31 about how they're supposed to show some level of agency, not necessarily saying as far as like with an oral argument, but if you're coming to represent. So, and I said it just like that. And the judge, like at first I said some case law about JB Colt versus Wheeler, and like how mere declarations aren't like, mere declarations doesn't prove agency. So some proof of agency must be proven or established to show proof. So from there, he's like, "Do you got a copy?" I was like, "No," because I'm thinking like, "I don't copy this mediation." So, but once I said about the Rule 31, he literally stopped what he was doing and he literally pointed his energy and direction towards the attorney. He asked the lady, like, "Do you have any proof, admissible proof that you are here to like represent the plaintiff?" Like the plaintiff, he was basically asking and reiterated everything that I asked. And from that point, I was like, "Oh, I just wanted to walk up and hold my arms up." I was like, "I got her." So make a long story short,
that attorney was punching the air like, ugh.
She didn't give him a direct. She was like, I did, but like she started talking around besides just giving a direct yes or no. So I was like, I know she didn't have it then. So when he said that, the lady said that, then the judge just looked, and then he was like, "Well, Mr. Austin, you got anything else to say?" I was like, "Nothing," because I talked for about 20 minutes, but I talked about so much shit. I can't say I got it all on recording though. And the judge, he said that we find that the plaintiff is not entitled to the premises, and that the plaintiff is not. He gonna deny the plaintiff what it was. I think a judgment for a money judgment. So for me, I was like, oh shit. Like I instantly was like, oh shit. Like in my head, I was like, oh shit. Like because I never really like. You could be arguing good like a motherfucker, and these people still gonna do what they're gonna do. So it felt good to like really go through that win and experience it. And I just asked the lady, I was like, she ain't showing no delegation of authority. I was talking about how the lady withdrew her motion, the attorney, I responded to her. She said she was gonna get back to me 5 o'clock, never got back to me and withdrew her motion to compel rent. Then we had the other attorney that came and never appeared, but he the one that filed the action. So I'm breaking it down to him procedurally, like, cause I'm like, I see how the judge, like he was cool as fuck. So I just gave it to him in a way where he could be able to like see one no attack. Like I'm asking simple stuff, but I'm also giving like the points and rules of law. So it's like it was just hitting a little different, like because I seen how his energy was. Everybody all friends, they all buddied up in the court and shit. So I'm like, okay, I'm quiet. I ain't say nothing. I just watched. Because when they called me and then the attorney spoke, she didn't even speak all of 2 minutes. When I say she didn't have nothing to say, she sat down, and when the judge asked her about that Rule 31, that was like the finishing blow. So from there, and then I did a motion for a Rule 42, which was a limited a request for a limited discovery, pre-trial discovery. But he denied that. But I was just I was just going because I had to remember it in my head. So I had everything compartmentalized. And
Hold
when she
on.
said,
What trust did you have, Elijah?
"Who? Stop sign."
I'm just saying. Did you have a DBA and a
Nah,
authentication?
no
Oh,
DBA, no
okay.
BBA, no NDA,
Authenticated
no
birth certificate.
SBA, no G, nothing. I came in there looking how I was looking, and I said what I had to say as far as like even with like that meaningful opportunity to be heard. I said that shit about 5 times. I kept saying that because I was like, we got to ensure that we protecting the integrity of this court hearing and proceeding, and I'll make sure I'm afforded a meaningful opportunity to be heard because I have a right to shelter. So like
Correct.
fucking them up, like I was just fucking them up, like because at first the judge was like, once I came in, I was like, yeah, my man. He's like, he didn't want to hear all that shit about all that extra shit. So I came in, I was like, because they was about to literally go move forward my case. I was like, no way. I said, fuck that. I went up there. I said, nah, I'm Elijah Officer. I came up there and from there we just started going. Because I seen how he was like kind of his energy changed when I was like giving him some just my stance on it. So I was like, let me just not even go that route and just give him exactly what it is that I want to really speak about.
That's right. Be
That's it.
yourself. Be yourself. You didn't have
I
to be.
walked out
You didn't have to be a
unscathed.
DBA, none of that. Be
And
yourself.
what's even crazier, this was like, I'm just excited because this has been going on since what? October. And we're like at this point. So it's like been a journey. And just want to shout out to Trader McGay, like for real, like the whole group, but Trader McGay really made sure like he was really on my eyes. Like, so I be meeting that and I'm just very grateful. Like I appreciate you,
we
right?
be wanting y'all to win more than some people be wanting to win. I'm like,
Yeah, I felt it. He be
let me
through the
win
phone
this shit for
talking to me.
you.
It be win energy, so I'm coming with that energy. I'm like, yeah, I'm coming. When I came in today, I wasn't scared. I was just my energy, like everything resonated. So today was a day where I just knew it was gonna flow. Not necessarily saying I knew I was gonna win or this, that, and third, but it was just my energy. I wasn't scared. I came in there, I felt good, and I was feeling good leaving out. So just a success story, y'all. I just wanna let y'all
That
know.
is
We ain't going
absolutely a
nowhere.
Sexy
success
story.
story because that is the point of class. That is the point of the community to empower you guys for real, not to keep you guys dependent on us. You know, I am so proud of both of you guys that shared today, especially since it's an eviction thing. That stuff is very, very close to my heart, if you will. I know that everything else is important too, especially the children. Okay, especially the children, but the children got to have a place to live. Yes, the
Yes,
That's a
dogs got to
fact.
have a place to live. We got to have a place to live. We have some places to keep our stuff. So it's a big, big deal when it comes to the housing stuff. I'm again, kudos to the
I
whole
feel
squad.
excited. Atlanta is a behemoth. Big ass things people be trying to do with this, that, and third. I'd be like just going there all the time and they just try to give me a hard time. But like I just love what I know. And that's what they can't take away from me. So I yield. Appreciate y'all. Hey.
I love
Appreciate
that
you,
Gracious.
last
brother.
statement. They cannot take what we know from us for real.
That's the
Why? So
fire that keep burning down everywhere.
yes, yes. Woo,
No
woo.
matter what you do.
Oh, you did a Jim Brown and whooped all
Salute.
their asses.
Salute, Elijah. Salute. But you said something that's important. It's something that I've done before, though. But whenever you cite sometimes you cite case laws, it's always good to have a copy, especially from the original publication. Whatever publication for the jurisdiction, it's always great if you could have a copy, at least, maybe not all case laws, but possibly one or two, depends on what you're using, for the
Yeah.
judge
If
to
you're
actually
gonna
read.
mention it, you know, or you might mention it. Good to always have a copy. Even the code. Sometimes the attorneys be like, "Oh, what was that code again?" And they gotta try to write it down, like that woman in Texas.
I even was talking about the legislative intent too, and like I like the enact. I got everything that you said, Trader Me. I damn near got everything. I was talking about everything. I literally, as y'all talk, I would just start thinking about what I was talking about, and that was like,
You can recall those things to top of mind when you are relaxed, when you're not feeling that pressure and anxiety from feeling incompetent.
And when you comprehend.
When you study.
Panic
No,
in the
people be coming
city.
on here talking about I've been studying for X amount of years. No. It don't come from studying, guys. The confidence comes from feeling competent. And you can study for years and not feel or nor actually be competent.
That's a fact. That's why I went in there
That's
and I was chill, even though I wanted to scream at the judge and attorney and flip the tables over and whip them out. You know what I'm saying? I had to stay cool. So
good job, McGarty. Give me some. Give me some.
what's up, brother? What's up? Hold on, let me turn my
Let me
camera
get a
on.
little
What's
bit.
up, bro?
Love it.
Trey, where's the success clip?
Hey, we need to invite each other over our houses.
You know what I'm saying? Yeah.
I got some peaches, brother. I'm get a peach clone good for you. Give
Come
me a
on
second.
down. We're gonna have a potluck in this year to me. Hey,
Wait a minute now.
just let me know. Ring the bells and saddle up the horses and come on.
Yes. All right. Who else got their hand up, guys? This is awesome. When this one gets shared on YouTube, make sure we're linking to the Beat the Bar class. Make sure we're linking to the rent free class. Okay. And of course, linking to the Newbie Tuesday download put together by the community to support all of what we're talking about. Make sure people are watching that entirety of the As Above So Below series. Come on, guys. Let's see. What else y'all got?
It should be McGarvey. I don't know if they're not aware that they're next.
Oh no, I had already. Is my hand still up? Oh, let me take my hand down.
I say Chase 7.
Okay, so we ending class right here.
Hey, Mylika, I wanted the opportunity to ask a question, if possible.
Go ahead and shoot, bro.
All right, all right. Well, first of all, this is my first call, so I'm definitely a newbie, and I just want to say thank you for having me. I've never been a part of a group that goes live and actually shows like real results, so this is very interesting. But my question was, I'm in the middle of a home sale process right now, and I was surprised today by the title company because I had my home and property in a private ministry. And upon sending over the certificate on Friday, it was almost like, I'm not a human after they realized what type of, ministry or trust it was. They got really, really weird on me. And today, the communication was, they can't do the titling because they can't insure the title or the deed because they don't feel as if the private ministry I placed it in was an entity that could hold title to the property. So, to make a long story short, I just wanted to ask, is there any type of reference guide or any material I could study within the group in reference to a possible quiet title process without having to spend thousands of dollars on a quote unquote attorney that I don't have, as I'm about 16 days away from closing and this just kind of messed things all the way up?
So the
Just
issue then is finding a title company who can um, continue this process.
Yes, it can't be a fidelity broker, they stated, because they won't be able to insure it. And the solution is to do a quiet title process, as I'm the only trustee on the actual private ministry. But that's going to take about 30 days and literally mess up my closing date, or find a broker, I guess, that isn't insured by Fidelity that could possibly help me with this. But my realtor has already explored those options where she's not able to find anybody.
So it seems to me like you kind of have your options laid out for you because you're on a time, so you don't really have a whole lot of options, right? Because you want to continue the same timeline.
Correct. Yeah, I was doing some research on the quiet title process. Like, I would have to send a demand letter to the address of the trust, give it 20 days, then file all the civil paperwork. I heard the gentleman earlier with the foreclosure situation actually state the document. I want to say it's like a lens. I don't know how to pronounce it. I'm a little new here, so lens itimus or something. So I'm doing my research to start the process. Just didn't know if there was anything here more factual than ChatGPT I could possibly study for guidance as I go through it.
I could definitely recommend Hassan. He's got some super fire large language models that he
Yeah,
could
and
provide.
go ahead.
No, I was just saying Hassan got some fire that'll definitely get you right. Or any one of them, having a consult with them is what I would recommend. Outside of what Leanna, I think it was Leanna that said that.
Definitely. Thank you so much for that. And are the consultation links on Freedom from Government website or here in the Facebook group?
They should be on Freedom from Government, but I'll put them in the chat, right?
Yeah, please. Thank you guys so much. I appreciate it. Thank you again.
What state is that at, Timo?
I'm in Arizona.
Okay.
Yes, ma'am.
Yeah, I give much better answers when I know the full story. It's not so easy to give things in a like flash type of situation like this. We can always give general um idea, but it would probably be good to look at the full of everything, the actual documentation, not just the narrative. And I hope that helps.
Yes, definitely. It definitely does. Like a full review of what trust it was in, the actual title search history, etc. So yeah, a consultation with exact paperwork would help. And the buyer is getting a little bit antsy today where they were threatening to cancel the contract if this matter is resolved. But with having to give at least a minimum 20-day notice, then go through court, it's going to be impossible to have anything done but by the 16th.
I would also suggest, your brother Timo,
Yes, yes, sir.
to check out the As Above, So Below series. It's absolutely free and it's chock full of information. Perhaps you would even reconsider what you're doing. I don't know, but it's just a suggestion.
Oh, yes,
Can
I'm
you do
actually. Go ahead.
Timo, can you do a holdover lease agreement until that closing date is something that you could do so that you don't, in agreement to the delays that you have, work something out like that.
Okay, a holdover lease agreement and
So
study
that
as
they
above.
can, yeah, so that because if they're selling a house or, if they're second time buyers and they've got, see what it does is a transaction chain. And so they're probably getting antsy because they don't have anywhere to go. And I see that a lot. It happens a lot. So if you got a place to go, before the sale's done, and then let them, you could, I've seen that before where they'll agree to let the buyer move in or, like do a contingency for whatever time you need before closing. You could do something like that. It's kind of risky, but it's an option. So you don't lose your buyer.
Thank you so much for that, Melissa.
You're welcome.
All right. There's some hands up. Ice. Want to ask a question?
Hey, yeah, I just want to second what McGarvey said. If you get what Hassan as far as building a large language model for you, I actually had happened to book Hassan uh, prior to getting served with child support documents. And as soon as I was entering, I was staring at my divorce decree for years, and his large language model kind of identified some procedural irregularities since we were touching base upon that. And it seems as soon as I started requesting certain documents, that child support case had actually gotten dismissed because I knew from dealing with this on that they had filed in the wrong venue. And just to touch more upon some going for some triple exemplified documents, trying to get the judges and the clerks to certify each other's signatures on those old documents. And it came back with just blank copies because it's clearly, even though it was supposed to be a judicial proceeding, it was clearly administrative because they said that they found no facts or conclusions of law and took no testimony. That's really where I'll land.
All right, thanks for that, Sides. All right,
Yeah,
Carrie.
gratitude, y'all. Appreciate y'all. Sorry, I'm out. Me and Lotus out in the garden, so I'm raking leaves while I'm listening. Gratitude. I heard that. Gratitude indeed.
Carrie has her hand up.
Hey everyone. I just wanted to check in on, I have a foreclosure case in Wisconsin and it was filed and then an attempt of service. They did publish it in the newspaper, but I'm on the steps. So I've been working with Malika and thank you. And also have the large language model from Hassan, which is awesome. So I sent the good faith notice out and I emailed it on the 24th and I haven't had a response. And then I mailed it out the same day. It just got received yesterday. So according to that mailing, their timeline of 5 days, the email timeline came and went, but the mailing is still going. I have a deadline according to their summons for, well, what they put in the newspaper publication says you must respond with a written demand for a copy of the complaint. And I know, Malika, you said to do that. However, I'm thinking I'd rather do a notice of motion, a motion to dismiss for lack of personal jurisdiction and then insufficient service of process. With the service of process, they came by the house 3 times, didn't find me. And then they have that affidavit in there. And then they had, they mailed it to the house, which doesn't even have a mailbox or a doorbell or any such thing. But they had the address, they had the proper mailing address from when they reached out to me prior to the foreclosure. And they just apparently, forgot about that. And then they put in an affidavit of due diligence and mailed it to the wrong address. And then they published it in a neighboring county. So they didn't even publish it in the county where the house is. So I was thinking about it, going about it that way, a motion to dismiss and putting that into the court rather than complying with what they're saying, which is respond with a written demand for a copy of the complaint. So just wondering if anyone had any thoughts on that.
If you are seeking to knock them out the park, challenging a procedural error that can be fixed is not going to solve the issue. Eventually, you will have to confront them. So at best, your tactic of challenging the service is a mere delay. Does anybody want to add anything else?
I would agree with that. I'm just sorry to, and I want to hear what everyone says. I completely agree with that. All that would do is if it got dismissed, it would just prompt them to redo everything they're doing. I'm just being specific here regarding, yes, the good faith notice, I did the regulatory letter that's been sent out and should have been received by everyone by now, but I have no responses on anything. And then with the deadline of the 2nd, but do you still think it would be best practice then to just respond to the court asking for the written demand and copy of the complaint?
Regardless of how you decide to do it, if you want to knock them out of the park, you're going to have to confront it.
Yeah.
So any delay tactic is just merely that. And so the question becomes, do you just want to have fun effing around and finding out? Like, just want to prolong it a little bit?
Not necessarily.
So then why challenge a dismissal just on service that can be amended, and then you're gonna be right back to where you're gonna have to either make a proper answer or some type of meritorious defense, or do a counterclaim, or do your own claim. You're still gonna have to do all those things. So why bother to go through the motions?
Right. So you think I should go through the motion of sending them a formal written demand for a copy of the
or something else that's not just a delay tactic.
Okay.
Like, oh, you didn't serve me. Oh, wow, we got to refile. It costs us a couple $100. It costs us maybe another 4 to 6 weeks, but we're still coming after you. So,
absolutely.
what? My question is, strategy wise, why would you choose to do that when instead of confronting them and beating them up?
I hear what you're saying, and I do want to confront them and beat them up and take this head on. That is absolutely the thing. I'm just looking at the deadline this week, and just that's why I'm here asking the question, because the publication said 40 days after February 21st, which would be April 2nd. So, what would be the best move? Given I haven't had any response from them, what would be my next best move? I need to do something with the court, correct, or not?
Eventually, you will have to do something with the court, whether you do it now by getting the complaints, reviewing it, and then making a proper strategy to include a motion to dismiss. But it has to be, in my opinion, for stronger reasons than mere service, because that is amendable, and then you're still going to have to be confronted. So,
okay, so
no need to delay.
Yeah, and I was waiting for some feedback from you too, because I have all that stuff uploaded for you, and was hoping for some more feedback on this as to the next step. I don't know if you looked at the complaint or not, but that's been in there.
I haven't looked at the complaint, but so you did get a copy of it?
Yeah, I've had the complaint for a couple of weeks. And
okay. So are you going to do a formal demand on the court or no?
Well, had sent you, I had asked you for some help on this, so that's what I'm doing right now. I'm asking for help.
Well, I mean, I already sent my suggestion and opinion, so it's totally up to you now.
Okay. So your suggestion is to just send a formal demand asking for a copy of the complaint, even though I already have the complaint?
I mean, just seeing somebody sued you online is not considered service. So I don't know how you're going to confirm service or how you're going to deny service since it's by publication. Even if you have an objection to the service, you're in the game.
Yeah, absolutely. So if this was your case, what would be your next move then while waiting on a response from the good faith and the regulatory review?
I do not wait on responses. When I have my strategy, I do the next step. So because this is Newbie Tuesday, this is a great question, because when we are new, we think that we have to wait on responses in order to do a process. But unless a process says that a response has to be had, then our job is to just go through the steps of our process. And let me explain when it comes to, let's say, eviction requires a series of notices. Everybody know what I'm talking about? When you go look at dispossessory actions, there's supposed to be notice and demand. Anybody know what I'm talking about?
Yes.
There's supposed
And
to
have to
be
prove that they gave
a
it to you.
15-day notice in some jurisdictions. Then there's supposed to be a 10-day notice in some jurisdictions, right? And then maybe even a 24-hour notice in some jurisdictions. Y'all know what I'm talking about? Some people know what I'm talking about. Let me get some feedback.
Uh-huh.
Okay, are any of those notices waiting for our asses to respond?
Absolutely not.
Do any of the notices say, unless the other parties respond, then you're supposed to just stand still? Does any of that is required?
Not at all.
Or is it just going through the motion so you can tell the court, if necessary, I sent the demand notice at 21 days. I sent another notice at 15 days. I said, here's my proof. I sent it. They don't give a damn about who responded to it. Anybody know what I'm talking about?
They sure don't.
So
All they
why,
got to do is put that they filed it
when we
or
have
that you
our
received it.
notices to file, we're always talking about whether or not somebody responded in order to do or not do the next step.
Well, there's always a next step, and I completely comprehend what you're saying 1,000%. That's actually what I'm asking. Is I'm saying I've done these other steps, and I'm anticipating what I'm working on doing something next, and I'm asking.
Yeah. Again, I'm going to say it again. I gave what I would do. I would face it head on, and I would get the official copy or official service or whatever you want to call it.
So by making that demand for a copy of the complaint, then that's the official service. Even is that what you're saying?
What do the rules say? What do the court rules say? What is the effect of a publication by mail, whether or not the respondent demands the service?
Oh, they can say, I mean, according to what they believe that they served me properly.
No, we're not talking about belief. We're talking about what the rules of service say when it's by publication. What is the next step for the respondent? What is the consequence, positive or negative, of not responding? Does it negate service if you don't demand a copy of the complaint? That's what you have to prove by reading the rules, or know by reading the rules.
Mm-hmm. Okay.
What happens if you don't respond in the 40 days? Do you get a default judgment?
That's what they allege in the publication. However,
I'm not talking about the publication. I'm talking about the rules of being served by that method. It has to have rules.
Okay.
And in the rules, it should say what the consequences are of if you do or do not respond with a demand for by publication. Is it presumed that you were published and therefore they're just going to enter a default judgment? Is that what the rules say? Because if it is, then you will lose by default on the 40th day, even though you have a copy of the complaint in your hand.
Right. I know something needs to be put into the court. I'm aware of that. Okay.
You could analyze whether or not they actually followed that service by publication statute in strict compliance.
I'm saying whether or not they did, even if it gets dismissed for that procedural error, they will simply reinstitute it, and therefore it's just going to be buying time.
Yeah,
it's not going to win your case sooner.
I agree with that, but it seems as if that's what she was trying to do, have a delay to do something else based upon what she said. That's the reason why I just mentioned that.
I think it's just a delay to delay, not as a strategy to
not a delay,
allow something else to happen.
No, it's not just to delay, it's just to do something, but not just ask for a copy of the complaint, because I already have the complaint and I have other things that I could submit to the court. That just seems stronger. Even if it is just a delay, it's not because I need a delay or want a delay, it's just because I already have the complaint. So asking for something I already have doesn't make sense to me.
Well, if you have a copy of the complaint and you want to use that as a reason that you don't follow the rule, you should still read the rule to see what the consequence would be.
Yeah.
If you don't make the demand. So if you decide not to make the demand because you have a copy, then you should make a meritorious reply to the complaint. Either, again, with a counterclaim, or if it's allowed, or an answer with your defenses, if that's what you wish to do.
Some sort of response, though. Okay, got it. I feel like, I don't know. I guess I feel like you know some of the other cases so well, and you haven't looked at mine, but that's all right. I'll figure it out.
I already said what I would do.
All right.
Does anybody else want to chime in?
Hey, I can
Couldn't get to my phone fast enough. I'm sorry, y'all. I'm raking, like I said. Use that remedy to your advantage, especially when it comes to seeing whatever was done, checking that up against the court rules so that you can maneuver. That is what Malika said. I'm just echoing or reverberating what she has already said. And when you check those rules and you see what the rules are, just for service of process, see if there were other things that were done prerequisite to them resorting to service by publication. Because to me, to my comprehension, in most jurisdictions, maybe not all, that service by publication is a last resort. I'm open for correction.
It is a last resort here, and they didn't do their due diligence in the other aspects.
So then what Malika is saying, and what I'll add to that, is use your state remedy to be able to effectively show the procedural defect in service.
But that's what I did, and she just said that's just buying time. That's not the proper avenue to take. That's just, so that's literally what I have in front of me. Is I drafted that.
That won't be the only thing you do. However, that is one thing to do, while at the same time focusing on them not having the right to enforce what they are attempting to enforce. That's your main focus. You can just show by, hey, this type of thing was supposed to happen or whatever, but maybe it's a tactic. Maybe it's a tactic for you to speak up. But when you speak up, just because you speak up doesn't mean you've been served. Oh, well, you saw it by publication, and yet that doesn't mean anything. No, it has nothing to do with, oh, by the way, you saw it. It has everything to do with the rules weren't followed. And, oh, by the way, do you have the authority? Do you have the right? Do you have the chain of assignment to enforce what you are purporting to enforce? That is the goal. Again, I'm open for correction.
Okay, and I'm hearing you. I'm it's like combining the good faith, that challenge of authority, and getting that chain, and challenging the jurisdiction or the process of service. Sorry.
Correct. I mean, because look, let's say they did process of service correctly. What are you going to do, Carrie?
Well, then that still moves forward, and then it still
moves.
I still have to do something.
Hold on, time out. We want to put you in the mindset of your favor. Moves forward for you to assert what on the record?
Their lack of authority.
By not bringing what before the court?
I'm not sure.
What are they not bringing before the court? Come on, y'all, help out.
Jurisdiction.
Proof of
Standing.
Right.
Proof of
A
delegation.
right to enforce, which is the chain of assignment, an unbroken chain of, repeat after me, unbroken chain of assignment. That's the only way they can be enforcing a foreclosure. If they're just saying, oh, well, we're just going to serve it this way, and then, Harlem Globetrotter style, we're just going to spin the complaint behind our back, pass it without looking to this other attorney. We don't care what you do. Do you have a valid chain of assignment? Produce that, which would be credible evidence before the court.
Bam.
That's credible evidence. And then what else you should be focused on is, okay, well, at the time you are asserting this complaint, who was the holder of the note, which should be the same person giving the authority to enforce the foreclosure? Woo, this feel like Friday. Y'all sure this ain't? Y'all sure this ain't? Y'all sure this ain't Friday? Let me go check my calendar. It sounds like Friday.
Friday.
That's the focus. Do not move from there. Anybody dealing with foreclosure debt, credit card debt, they trying to take your will. Again, always, always, always. Them helping themselves to a plate where they weren't given permission to help themselves to a plate. You have to kick their ass there because that's the procedural defect. Is that clear?
Yeah. Property only passes. Property does not pass by just money. Property passes only by assignment. That's it.
If you ain't give them permission and the so-called holder of the note ain't give them permission, then how do they have any access to your data? Huh? How? That's not for you to answer. That's for them to prove. Because they're the ones making the complaint, and they have to prove that beyond a shadow of a doubt. Put that down.
They ain't get it out the trash, did they?
Yeah, that shiny trash can called LexisNexis, right? Put it down.
Thank y'all for finally decoding the Morse code.
Thank you, Hassan.
No worries, sis. No worries. Gratitude. All right, I think Mel was going to go next. My apologies, Mel. No, y'all good? Who else hand up? I'll check this participants list. Oh, okay. Nobody else? It's an early class, huh? Is it early class? What's going on? Oh, 4 minutes over. Well, I yield if y'all yield. I'm finished raking these leaves. You heard, Big Bird?
Big Bird.
Yeah. Well, it's 5:04. If we don't have any more questions, does that mean that we are complete for the day?
Sounding like it, y'all. All right. Well, this is good.
Oh no, Melissa just put her hand up.
Okay, Melissa's back.
All right, you'll be last, Melissa.
Go right ahead, then. Go right ahead. Sorry, let me mute my mic, y'all.
So I was just going to chime in. I wanted to tell you guys, after 6 years, I finally found my answers. They were in front of me the whole time. As dumb as that is, you were talking about service. So part of our cases are about service. And I know that doesn't get rid of it all, but Minnesota, what they do is they'll send hearing notices for these criminal cases. And when you have a summons, you have to be served, which I didn't know. They also have something in Minnesota about warrants.
and failure to appears that they have to give you a sign and release as long as it's not domestic or, you know, you hurt somebody. But in our original complaint, it says they were securing the property to get a search warrant. The charge is obstruction of the legal process. So, common sense, logic, and reason says that if you didn't have any process in your hand, you can't obstruct, correct? Just looking for feedback here. Logic. And I missed that one line in that complaint this entire time.
So you're saying your goal is to contest the service right now?
Well, if there's no service, there's no process in hand to obstruct, correct?
Which came first, the chicken or the egg?
Well, I'll read it to you guys real quick because it says October 31st, 2019. They came to my house to enforce a custody order. Officers were informed that the county judge had signed an order granting sole physical and legal custody of a minor child to GB, which is, you know, that's our family member that is a turd. The child was located at the East Bethel home, and GB was requesting assistance to retrieving the child and enforcing court order. And it goes on to say, officers responded and learned that the child was inside the home along with an individual identified as me and refused to turn over the child to officers. Even when informed of the court order, informed, nothing in hand. Officers attempted to explain the situation and the consequences of not turning the child over, but she refused to do so. I questioned the authority of the court and the jurisdiction of the officers and their ability to enforce the order. At one point, officers could clearly see the child inside the home, and I refused to permit the officers into the home to retrieve the child to surrender the child to them. And this is the next part that got me. It's been sitting there for 6 years. Officers froze the scene and prepared to obtain a search warrant for the home while officers maintained perimeter around the house. I exited the home and began photographing the officers around the home. At this point, officers detained me to prevent her from re-entering the home, possibly barricading herself in the home. It all sounds like a narrative of a freaking cop show. So, that's my humor. And then it says approximately at the same time, my son was walking across the street to come home, to come and see his son on lunch break. And then it says, the defendant herein, the defendant observed officers detaining Miss Grover and attempted to intervene. Officers ordered him to stay back. If you're obstructing, you're not going to be, you know, I'll get to that in a second. And stay back, and that had been established, but he refused. Officers were forced to take the defendant to the ground to prevent him from intervening. Well, that's not what happened, but anyways. Then the last sentence says defendant was issued a citation, subsequently failed to appear in court. That was filed it was on the same complaint dated October 31st, 2019. Well, in January 6th of 2020 is when they filed the complaint. The problem is there is never any service for the summons that's in there. So if you were doing an obstructing of a legal process, you would have the custody order in hand, you would have an application for a search warrant for things and places to be seized. All of these things right here were sitting there the entire time. So what the rules say is that and then that ex parte order from the little twit judge in the other county says that he's allowing her to serve us, and that violates the civil process rules because it's the adverse party. So anyways, those are the things that I found, and it's quite interesting when I started seeing that, because common sense, logic, and reason, if you were having a process in hand and they're telling you you're obstructing, How can you obstruct when you didn't have anything in hand to obstruct, correct? Am I reading that right?
I think there may be some logic to what you're saying. I think it would be really good to see everything written out because just listening to it, I don't know about y'all, but it's hard to be like, yeah, that makes sense without really looking at it and reading the language, right? To make sure that
Yeah, I
we're
get
making
it.
sense.
Well, I've already written it. It's already done. And then I found something else, you guys, because I know this goes on everywhere, and I don't know if you've heard of this term before, but it's called serial prosecution. It's where they stack in warrants. And so when they did not have the original process, and then subsequently you have these failure to appears all the time, and that's why we can't get rid of these warrants. And what they do is they're stacking them. And that was my word, but then I found the serial prosecutions because in these cases they were layering on top of the initial, which if they didn't have the process to obstruct, all of your cases fall. So
Mel, would you be willing to share your dot with us maybe on Friday? Would this be considered a court strategy question?
well, I'd like to just meet with some of you guys private just because I think once some of the stuff that I found will help a lot of people. And then there's another thing about probable cause. There's two cases that we can all use, and it's Ohio versus Beck, and then it's a Watley case. I think that one is Minnesota though. And then everybody thinks that over the weekend they're not going to let you go because that's what it says, except for in probable cause situations. And and it's very important, I agree with Malika, is you read those rules and you really understand them. It really helps because the second arrest, they arrested him and they changed the dates on the probable cause application. Said he was arrested on the 7th, he was arrested on the 6th. So when you start reading the rules and it says, and it includes the weekends, then all of a sudden everything falls. And then they committed perjury because on the 9th and the 10th, they are saying that they were within their time frame and they weren't. It ended on Sunday. So I don't know. It's just the more I've been digging into this, the more it's like I feel like bitch slapping myself in the face. It's just because I want to tell some of these newbies, I know if you get stressed out, and I've been dealing with this cases for 6 years, but the answers will come to you. But just take some time and walk away a little bit and then go look again. But
let me add to that, Melissa, because with you saying that the rules is what had got your mouth, boy. The rules have been what's giving you clarity. That is a testimony to slaughtering, slaying, killing, unaliving every marketed process out there because most of them don't come with make sure you read the rule disclaimer. I'm open for correction.
yeah, in essence, but then you can see I've got all of the sheriff complaints and all of their reports and stuff too, and they're always contradictory. But when I saw the judge in the ex parte complaint or in the ex parte order, he's given her carte blanche, and she didn't even have legal standing or mental capacity to even file the case. And so I dug a little bit further, and the interesting thing was with the freeze, officers prepared to freeze the home.
Scene.
It says freeze the scene or whatever it says right here. They have to have, and it says it in here, they have to have a search warrant for the home. Well, and you go look in the court records and you look in that court registry, there is no application for any warrant. But in the other complaint, in the deputies, this is where you're going to get them even more because it says the sergeant. I know a lot of you saw these Facebook Live when all this happened 6 years ago. There's 3,000 people watching this. And it says this dummy that slapped all these papers out of my hand and slapped my phone out of the hand. He is the one that said that he had a warrant for the residence, which he did not. And when you go back and start learning what to look for in that registry and doing your audits, you're going to find your answers real fast. And so I went back in these reports. They gave most of them to me redacted, but still there was enough there to show that the misconduct, just in their own words. And so that case should have never been filed just based on their own probable cause. Because if you're doing obstruction of the legal process and you're telling me that you were just notified of an order, but you didn't have it in hand, you can't obstruct anything. So common sense, logic, and reason, you had no case and you had no business filing this case. Now I'm really coming for you. So, the rules, I mean, I've got probable cause orders that this judge signed, and he was arrested on March 6th, and they're saying the date of arrest is March 7th, and it was to evade the constitutionality part. So also I'm going to tell you guys, use that as applied challenge, not the facial challenge, and make sure that you're clear on that for the 609, like Minnesota 60950 for the obstruction. Because they should have let him go, and it says that right in the rules. And then in Rule 6, it also says it's supposed to be a sign and release. So even if you have a failure to appear, they're supposed to be signing and releasing you. They're not supposed to be putting you in jail. Timeline. And you look at those timelines and stuff and really dig into it, and you're gonna see it. So just some tips I'm sharing out there. I haven't been on here for a while, I miss you guys, but it's really helped a lot to drill down and rip this sucker apart, and this is what I've done.
Record
Federal
preservation
rules or
is
state
key.
rules?
What's that?
Is that federal rules or state rules?
State rules. But still there's still coinciding federal, but some of them I've been using both just for the fact that, when I do my 1983, but and Minnesota seems to have a more stringent, instead of the Fourth Amendment, it's Article 1, Section 10, where it's even more strict. And then obstructing the legal process, this is what else I was going to tell you guys, is that it's very narrow. You have to have fighting words or physically obstructing. And when you read this complaint, it says they told him to stay back. Well, if you're intervening, you're staying back. They contradict everything in these complaints. They tell on themselves, is basically what I'm saying. So look for that. It's just some tips I'm learning. They will tell on themselves of what's wrong. It's always the accuser is the one doing. I learned that very young. So, but yeah, I've got some of this written up, but I'm just still hesitant because I want to make sure I hit everything. There's also a rule called rule of lenity, and that's when the ambiguous, we talked about that before with the word person, but I've been using it in the sense that you're not, the ambiguity of the charge itself is you're saying that he obstructed or we obstructed, and at the same time you're saying that you didn't have a process that there was to be obstructed. So the rule of lenity, look that up in your state, because I think that could help people too. It's just some things I'm getting out there for newbies, because I'm not a newbie by any means, but it's been really an emotional drain, and we're losing everything because of it. Literally everything. So yeah, but I'd like to, if anybody's free, I've got this and I'm not emotional anymore. It's all rules, it's all chronological on what they didn't do and what's absent from the record. So
you got a baptismal certificate?
well, no, I don't need that.
I'm just saying it seems as if you've been baptized. To the rules, I'm saying.
Yeah. Oh, and my other question, you guys, because you were talking about foreclosures, which I have not delved into yet, but now I've got that on my plate as well. And I know trading, you're pretty awesome at that. And the summons that we got a copy of, it was over a month ago, but we can't get our mail because we can't go home. So It's a bank in South Dakota, but the attorneys are in North Dakota, and the summons was not filed yet. Have you guys run across that in your foreclosure stuff? Because I looked on the court record, nothing has been filed.
Looks like a collection letter.
It looks like a collection letter, and I know they're not supposed to do that. But it literally says a summons, it says all this stuff, but there is no court file number in Anoka County.
I'm still in the grace period, I think.
So I didn't know if you guys have ever run into that or not. And what your thoughts are. Hello? Did I lose them?
Yeah, you're being heard. No,
Oh, okay. So yeah, that's kind of what I was wondering.
I went back to Reagan. What was the question?
So on top of all this other stuff we're losing because of these cases, we just got a foreclosure. And we only got a copy of the summons, and it was supposed to be answered back in February, which we can't get our mail because we can't go home. So it does not have a court file. Like it looks like it's been filed, but it hasn't. I checked on the court registry. There is nothing there. There is no judgments. There is no hearing notices. There is no nothing.
So it's just a notice in an attempt to collect the debt. That's what that sounds like.
But it looks official, like it's a summons.
You know what? You know what else looks official? A faux Fendi bag or a faux Gucci bag. Those look official
yeah, I
too,
know.
but they're not real though.
I know, but anyway, so I was just wondering if you guys have run across that yet. So, and so that's the next thing after I finally get these papers filed, and then I'm going to tell you guys something else too. There's some people that, just this is for the advanced people when you're helping. I just wanted to, and we know this, but some of the people out there don't. So when we're showing documents and stuff, I'm just going to say this to be cautious because the people that don't know and they're taking these documents and then just using them and throwing them at the wall, hoping they're stick. And we talk about that all the time, but I know a few people that they're doing that, and some of them should have known better and they didn't. And so now they've gotten themselves into a really big mess. And instead of being slow like a turtle like me and being cautious on what you're putting in there, don't be so quick as a newbie to file anything and put it in the record, because if you're not sure, make sure you get some second eyes out there because it could really, really hurt you.
Use multiple chatbots and so on.
And the other thing that I've been doing is using multiple chatbots and kind of verifying them against each other. And that seems to give you good results too. Just a heads up. I know, Hassan, you do that once in a while with Plexity or the one that Malifa hates, but I've been using like 3 or 4 of them, and it'll pull out things that I haven't seen in 6 and 10 years, and I can't even believe it. So
well, this is the thing. It almost sounds like a conversation. So
these people out there are just taking whatever you're putting out there and they're putting it in their stuff. So you have to tell them this is where the point is in this case. That's the problem that some of these people are having. And that's all I'm calling you out on, is because you have to say, in this case, at this time, in this process, in this state, this is what this case is about. Don't take my documents and throw them at the wall in your case, because it might not help you.
Oh yeah, we're always making sure people are at least they get the notice that it's jurisdiction specific, and to find where whatever is shared in that particular jurisdiction. However, again, I can't fight the parasites in certain people's bodies.
Well, I'm just saying that I'm seeing some of that going on, so I wanted to, just give a heads up to some of you guys out there, because you can't do that. and hope that it works, because it's not.
Indeed. Y'all hear that, newbies? Y'all better make sure y'all comprehend. Nah, but that's real though, Mel. I know I joke a lot, I jest a lot, but no, that is absolutely real.
Bots are at the PhD level too. So unless anybody pull out some PhDs, then yeah, I'd like to challenge that.
I mean, hey, that's
multiple bots. You got 3 PhDs consulting about the documents you're trying to enter. It's not what you say, it's how you say it.
Yeah, I agree. I agree. Most and foremost, it's like, even if you don't use the PhD language.
Throw my 2 cents out there.
Yeah. Say that again.
Can't hear you. The furnace is on.
Yeah.
Go ahead.
Y'all hear me now? Y'all hear me?
Yeah.
What I was saying was, see, even if the PhD language isn't used, the most important thing is to make sure that people are comprehending what is taking place. You know, instead of saying chain of assignment, let's just look at it like this. When you went to a club and you checked your coat in, when you went to go shake a tail feather and cut a rug, when you came back to get your coat, you better had a fucking ticket to get your coat back from coat check. Now, if somebody else is saying, no, that's my leather coat right there, then the question is, if you're the coat checker, you're always like, well, where's your ticket? In other words, that's your proof. Now, in foreclosure or many other places, it's called chain of assignment. You see what I'm saying?
Yeah,
so it's the concept that's important, so that people can find that concept. What's the word?